Hello, my name is John Milburn. I'm the course coordinator for Laws 11046, Law and the Environment. And this is a reconstruction of the live Zoom video that occurred last night. We had some technical issues, so that's why I'm re-recording and presenting this material. So this is for weeks 1 and 2 of Term 1, 2017. If you've enrolled in the course, thank you for doing so. If you're watching this video elsewhere, you're most welcome to do so. And I see that some of the videos I've produced have been seen by many people. One of them, latest count, at about 7,500. So feel free to pass on the information. Anyway, this afternoon's video as a reconstruction will be quite short. It's an introductory session, and I wish to raise a couple of key issues with you. The first is the textbook. The text that we are using is Jerry Bates' publication. This is the 9th edition. It's an excellent publication, Environmental Law in Australia. It's pretty substantial, and in this course we cover the great bulk of the work. However, I'm going to show you the emphasis, which is pretty obvious when we look at the course profile. If you don't have access to the 9th edition of Bates and you're relying on the 8th edition, it's also an excellent publication. Obviously, there will be some difficulty associated with trying to compare the editions, but I'll try to make that easy for you. I'll provide you with some notes about which are the corresponding chapters. I'll also provide you with some commentary in relation to both the 8th edition and the 9th edition, which is, in essence, a summary of each chapter. The idea of that is that you'll have an opportunity to watch and or listen to what I say about each chapter. I'll extract the important parts, provide some annotation and commentary in relation to what Jerry Bates says. But a word of caution. What I say won't necessarily be what you believe is the important part of the chapter. So read the material independently of what I say, because you may read it in a way that you feel that the emphasis is different to the emphasis that I place on it in the summary notes that I provide to you via those separate Zoom sessions. Okay, let's have a look at what we need to achieve this term. And the starting point is for me to share the screen, and we'll have a look at the Moodle site. So unsurprisingly, everything revolves around the Moodle site in this course. And if you haven't carefully looked at the material on Moodle, I encourage you to do so. In terms of format, you may, for those of you that are returning to the university, you'll see that the style is a little different. And the style that I've adopted is one where I try to minimize the content so that you have access to the materials you need without it being overly cluttered. And I hope that's not giving you vertigo as I scroll down just for a few weeks. But you'll see that there's a familiar and consistent format in terms of the way in which the course is presented. Each week, you'll see the weekly objective. You'll see that there's a problem in most weeks, not in week 2. The lecture material, the readings, the assessment information, which is only for week 1, further resources. Week 2 includes the problem, and I'll talk more about that shortly. So do try to follow the logic that I've applied in Moodle and work your way through that. Okay, well, let's start with the landing page, as I call it. The landing page for 11046 provides some basic information about me and my photograph there, crew, Zoom, and some background to me. Also some commentary about CQU Law having launched a Facebook page. I appreciate that you're not studying in the law school, but you're most welcome to have a look at the CQU Law Facebook page. There might be some interesting material for you there. Okay, let's talk about Zoom first. We're recording our sessions on Zoom. That may be an unfamiliar platform for some of you. It's a platform that I've used for quite a few years at the university. In the law school, we were, I think, the first to use Zoom. And I did start my career here at the university using Blackboard. I find Zoom to be far superior. That's just a personal comment. In terms of the meetings, we'll meet on a Thursday evening at 6 p.m. Now, occasionally, we'll start at 6:30 p.m. We may do that 3 or 4 times during the term. I hope that doesn't cause people great inconvenience. But I must say that we didn't have many people attend the live session yesterday. So by changing the time slightly, that may in fact encourage more people to attend. I do run a complementary course to this one in a different school, and it may be that on certain weeks I can combine the classes so that we'll have a greater opportunity for interaction in this unit, which is not heavily subscribed in terms of number of participants. I do record the Zoom session each week. I'll upload it through Moodle and you'll have an opportunity to catch up. I do urge you to ensure that you follow the sessions each week and make sure that you look at the session if you can't attend in person. I'd rather you attend it in person. It gives you an opportunity to interact, ask questions and become more engaged in the process. Speaking of asking questions and being engaged in the process, the second platform for communications between us will be primarily UCrew. Now that's likely to be a new platform for many of you. You'll see that we're not using Q&A or assignment discussion or general discussion. It's not there on the top left-hand corner as an option available to you. So our discussions are through UCrew, and now live, I'm going to go to the link for UCrew and we'll just see what's happening. Now it should be that you simply scroll down underneath the latest information commentary and see the link to the UCrew course discussion. It's like a little green jigsaw puzzle piece. So we'll click on that. It takes a little while. The internet that I have here in Hervey Bay is particularly slow, and I've just come back from Tasmania where they have NBN, and I can't wait to improve the quality and speed of the internet. All right, so we'll see if we can log on now, and we'll see here that this is for laws 11046. All right, so we've got some commentary already. Suzanne Sutton, thank you very much, has added some material. Wendy Hunter, we've been having a bit of a chat on UCrew. John has made some comments, but really you can see that that's a very, I don't mean to be unkind, but that's a really poor effort. We need to improve substantially when it comes to interaction through UCrew. So I want this course discussion to be buzzing. I want to see lots of questions of me or of me and your colleagues or of your colleagues. I want to see material posted. I'll post material, but I do expect that from time to time, when you come across material that's of value to you and you believe that it might be of value to your colleagues, that you post it and share that information. Now, it may be that you put in some commentary that I disagree with, or you may respond to another colleague's question and I may disagree, in which case I will very politely advance my thoughts on the matter. But can I say from past experience, and I've been doing this for about 5 years now, I think, at the university, overwhelmingly the material that people provide and support each other is very good quality. So I expect it will have the same. So don't be shy is the message. Go on to UCrew, ask a question, post a comment, provide a link to something useful. All of that is advantageous and I will certainly appreciate it. You can email me if you like, but it may be that if the response I give would be of general interest to students, I'll respond to you, but I'll also invite you to ask the question again on UCrew, and then I'll cut and paste the response that I've given to you and place it on UCrew. Probably a couple of reasons for that. The first is that I want to ensure that there's no perceived bias. I want to ensure that people don't feel that they're advantaged or disadvantaged by having private communications with me, where the information I give might be better served if it's publicly known, if I can use that term, for all people in the course. And also it may be that other colleagues have a perspective which is of great value. So the shared information, the collaboration, is of great value. Now, I use the word collaboration and I contrast that to collusion. You must be aware of our policies in relation to plagiarism and collusion as opposed to collaboration. So collaboration is where we're genuinely discussing matters that are relevant to the topic, and we're providing our opinion, commentaries, supporting that with cases, legislation, or material from third-party sources. So all of that is excellent. And I want you to do that. Collusion is where you're directly cheating from each other by essentially copying material in terms of assignment work and exam work. Okay, let's have a look at the top left-hand corner. You'll see the E-unit profile for the course. That should be familiar to you. I'll just run through a few things. The general information about the course is pretty obvious. The overview, we've got 25, 25 and 50 as the assessment. We have the university policies. Have a look at that, particularly in relation to academic misconduct procedures. You need to be right on top of those issues. In terms of previous feedback, you'll see that there's some notes about UCRU and continuation with that, and also the textbook. The unit learning outcomes are pretty straightforward, and the textbook, as I mentioned, is the 9th edition. There are some other excellent textbooks, and I'll refer to those from time to time. One of them is Fisher, which is a very similar style of textbook to Bates, and it's a very close call between it and Bates as to what should be the prescribed text. Another is the Environmental Defenders Office advocacy textbook, which is the Community Litigants Handbook. And that's a terrific resource. It's only cheap, it's about $55, and it provides you with some good precedents in terms of court documents. Now, very importantly, the referencing style is the Australian Guide to Legal Citations, AGLC. Sometimes by mistake I say AGLC, sorry, AGCL, but it's the AGLC. Many of you may be familiar with Harvard referencing, which is essentially where you're referencing in the body of the material. The obvious difference with the AGLC is the use of footnote referencing extensively and essentially exclusively. The best way to describe it is have a look at your textbook. You'll see footnote referencing, and really what Jerry Bates does is comply with the AGLC requirements. Also look at cases. In many cases, the judges use footnote referencing. So when it comes to your assessment work, do make sure that you have footnote referencing. Don't provide Harvard referencing. You can, if you wish, go beyond the use of footnote referencing by including an index or contents. And if you wish, you can include a bibliography. You don't have to. I think these things are good practice, but you don't have to. And if you like, you can add a cover sheet. I actually think that's a good idea to provide a cover sheet. All right, we'll talk more about assessments as we go through the course. Teaching contacts, of course, is me. The schedule for the course is laid out. Now, when you look at that schedule and you look at the chapters of the text that you need to consider each week, just as a general guide, if a week has a chapter to itself, then it's probably a more important chapter than a chapter which is part of a group. So, for example, in week 8, you'll see that we have 7 chapters. So that's where I would employ my speed reading skills as a student to work your way through those chapters fairly quickly, as opposed to, for example, chapter 11 dealing with environmental impact assessment, which is clearly very important, one that you must be on top of. I tend to write assessments and examinations that, where possible, have a practical bent to them. So I thought, well, the best thing we can do is provide you with a toolbox and give you some commentary about environmental prosecutions, which is criminal law. So that's weeks 9 and 10. And then week 11, community litigants and ADR procedures. So week 9 tends to deal with civil proceedings in environmental law. Week 10 is criminal proceedings, and week 11 is issues to do with who can take action in the courts as a community litigant and what are the alternative dispute resolution procedures that are relevant to environmental law. All right, so let's look at the assessment task in a bit more detail. You'll see the first task is an assessment that is due on Thursday the 4th of May. It's due at 11:45 p.m. and if you're late, that's okay, but you will suffer a penalty of 5% per day for late submission until the nominated cut-off date, the 13th of May 2017. Unfortunately, if you submit your work after the 13th of May, you will receive a 0 mark. Now, the reason I do that is I've committed to providing feedback to students at the start of a week 10, which is the 15th of May. And I can't do that while we have student papers outstanding. So you must have your material in on time. Now, let's talk about extensions. If you're going to apply for an extension, you need to do so through the Moodle site. You need to have your evidence supported with independent evidence, medical certificates, employment letters, etc. What do you think your chances of getting an extension are, given that in week 1, you know the assessment, which is due on week 8? They're probably not very good. So if you, if you have like maybe a flu or a cold or something in the last week and you have a medical certificate saying, look, this person is not fit to do work for 2 days, the response will probably be, no, not willing to grant an extension, because by the time we got to the second two last days before the assessment is due, you should have been at least 95%, and that's a matter of just polishing off the last bit. So don't expect to get extensions too readily. Sorry to be tough, but that's just part of the commitment that we make. The second assessment is due in week 10, so it follows on very quickly. And you'll see that the important part about returning the assessment to you by way of feedback at the start of week 10 is that it at least gives you something by way of feedback from me before you have to lodge the second assessment on that Thursday. And then, of course, we have the final assessment, which is due in week 12, again on Thursday. Now, on that occasion, as a take-home exam, you can't have an extension. So you either make it or you don't. You've got a limited period of time, and you must ensure that you comply with that time limit. So the usual rule about suffering a 5% penalty for late submission does not apply in that instance. Okay, so that's the unit profile. News forums, top left-hand corner, that's really just for me. And from time to time, I'll make, if for want of a better term, an announcement, and that's just simply a statement of something for you to consider. So it's not interactive as such. Okay, let's just look at the assessment regime, the first one, which is due on the 4th of May. So at this stage, plenty of time, but make sure you keep at it. All right, so what are we trying to do here? We're looking at a decided case, and I'm asking you to identify the background and the legal issues, and then I'm asking you to apply the law to the facts and explain the way that Her Honour Judge Boskill applied the legal rules to the factual issues. So in a way, that's a pretty straightforward exercise. And we are, if you like, pitching that first piece of assessment at the final product. So environmental law in Australia is all about the way in which the laws are applied in an administrative and judicial manner, And what we're seeing here is a completion of the executive administrative processes leading to litigation, a completed trial, presentation of all evidence, the arguments presented about law, and ultimately a decision by a judge. So we're looking right at the end to say, okay, this is how everything ends up, or it's an example of the way in which something might end up. And then we kind of work backwards from there in the assessment. So what we've got in the second assessment is an exercise where you need to talk about some of the factors. And I'll just give you some forewarning. I'm just going to have another look at that part B because I may change it slightly. So I'll give you plenty of advance notice on that. Now, part C of that first assessment is where we look at the way in which the laws are created and the basis upon which the Commonwealth is able to pass environmental laws. So we're kind of winding things back. We're now looking at the stage before litigation and we're asking ourselves, why is it or how is it that the Commonwealth is able to make environmental laws? Look, we'll look at this during the term, but in simple explanation, the Commonwealth doesn't have power to make laws unless authorised to do so under the Constitution. Section 51 provides for a number of subcategories in relation to which the Commonwealth has power to make laws. And environmental law is not one of them. Now, it's unsurprising because in 1901, nobody had heard of environmental law. And to be honest, when I did my study at University of Queensland in the late 70s and early 80s, nobody talked about environmental law. It wasn't a subject. It wasn't a chapter in any one subject, and it wasn't even discussed in any of the weekly seminars. So it's a new area of practice. And so it's not part of the Constitution, but in order to in order to enact Commonwealth legislation, the Commonwealth was able to rely upon other powers that it does have under the Constitution to make those laws. So, for example, trade and commerce or corporations or international relations, they're the basis upon which the Commonwealth has been able to make laws. So, for example, the Environment Protection and Biodiversity Conservation Act, which is the principal piece of legislation for the Commonwealth, is enacted as a piece of environmental law, but based on other powers. And in your reading, you'll see there's a lot of discussion about High Court challenges in the 80s, in particular, the Tasmanian Dam case, before that, the Murphy-Oils case, where the states challenged the laws that had been made by the Commonwealth in relation to environmental issues, only to be essentially struck down by the High Court, and the High Court confirmed that by using these other powers, the Commonwealth was able to make environmental laws without specific environmental power to do so. Anyway, we'll read about that. And so the idea of Part C of the first assessment is for you to explain some of these things in a way that makes sense to you. So you can see that we're winding back. We're looking at the final product. Now we're looking at the laws that were enacted, at least at a Commonwealth level, to enable the litigation to proceed. I'll just share the screen again, and we'll go back to the assessment regime. Do have a look at the rubric and the marking guide, and we'll give you an idea of how to go about doing your assessment. Okay, let's look at the second assessment due on the 18th of May. All of my assessments will typically be due on a Thursday at 11:45 p.m. I'll give you a little hint. I don't actually close it off until 11:50, but it's due at 11:45. So if you're a couple of minutes late, don't stress, it'll still go through. But if you're 10 minutes late, you will suffer some penalties perhaps. Okay, I'm not actually that tough, but let's assume that we're getting everything on time. Okay, now the second assessment is winding it back to a stage where it's before court and it's therefore not something which is considering the judicial issue of environmental law, but we're dealing with the executive or the administrative issues in environmental law. So if you've studied any law in the past, you'll know that we have the separation of powers, and the separation of powers, the Westminster system, essentially provides that we have the parliamentary wing, if you like, we have the executive or administrative wing, and we have the judicial wing. So we have the three. The judicial is where the matter is decided. The parliamentary is where the law is made. And the executive or administrative is where the law is put into practice, dealing through government departments and agencies, etc. So the second assessment is really pitched at that level, which is before court. And I'm not suggesting that these matters do go to court, but it's one of those preliminary stages where it may become litigious if something goes wrong. Okay, so what we need to do is consider a case study. I've selected the Townsville Port Expansion Project, and I've asked you to read certain material in the environmental impact statement applicable to that application. I've asked you to consider documentation which is available through the Coordinator General Project's website. So the Coordinator General has a particular role to play. It's especially important when we're dealing with large-scale environmental applications, particularly if they involve both state and Commonwealth jurisdictions. So I'm not giving too much away by saying that this is one where you need to consider the statutory approval process, both at a Queensland and Commonwealth level. My apologies for those of you studying this course outside Queensland, but I decided to go with a Queensland application. But the principles are the same, whether you're dealing with this matter in New South Wales, Victoria, Western Australia, or wherever you may be. Okay, so what I want you to do is to consider certain documentation and provide some commentary. Again, 5 relatively easy marks, providing me with a statement of the background. And then I want you to explain the statutory approval process. So you'll understand, of course, that administratively, people lodge applications. And if you're applying for an environmental approval, you lodge an application. The application sometimes is very simple. Other times the application is complex. And this is complex. And the application fits within a statutory approval scheme. Well, 2 schemes, state and Commonwealth. And they work in conjunction, they're intertwined. And what you need to do is describe the statutory approval process. And to do that, you need to understand the processes. So you're describing the processes within the context of this port expansion application. So I want you to consider the approval process under the EPPCA and make some comments about certain ways in which the Commonwealth and the state laws interact. And what you become familiar with are things like bilateral agreements, which regulate the way in which the Coordinator General and others deal with these sorts of applications. Okay, then you need to consider additional information in relation to environmental impact statement, and you need to consider the manner in which certain information in the EIS documentation is considered. Part of that involves consideration of things like the implementation of offsets to compensate for significant residual impacts. Offsets are really a way of getting around something, typically through the use of payment of money, in circumstances where it's not directly possible to deal with an issue. Pay particular attention to the matters of national environmental significance and matters of state environmental significance. So you need to understand what they mean and how they are relevant in the context of this assessment. And then, of course, you need to consider some aspect of the terms of reference, and I've selected one section of the terms of reference documentation, which is section 6, dealing with social values and management of impact. What you will see once you get into the course is that the terms of reference is really what is presented at an early stage, around which the material which follows is provided. Okay, so that's the second assessment. The reason I like to present the material by way of assessment straight away is so you know what you're studying towards. And it gives you a good opportunity to say, okay, this is what I need to achieve at the end of the course. As I'm reading, I'm looking for anything that might be relevant to that matter. And I'd recommend that you keep a couple of draft documents accessible at all time as you're going through your reading. And if you come across something in chapter 3, which might deal with, say, common law issues, then you can transpose that into part of the material that you need to cover in your assessment. Okay, let's have a look at the final assessment, which is worth 50%, and that is the take-home exam. Now, it's released on the 31st of May, on Wednesday, and it's due on the Thursday, the 1st of June. So no acceptance of late work, 50%. Now, you might think, oh, gee, that's pretty tough. We only get to see it at 6 o'clock the night before it's due, and it's due at 11:45 p.m. the next day. It's actually a bit generous. Normally, we allow 24 hours, so I've given you an extra 6 hours virtually. So you've got 30 hours, in essence, to do this assessment. The alternative, which we used to do, was a 3-hour invigilated examination. So think of it as you've got 10 times as much time now to complete this task than we used to. How good is that? All right, so I'll provide you with some hints and some thoughts about what might be in that assessment as we proceed. And mostly those hints will come through Zoom sessions. So make sure that you attend the Zoom sessions, or at least watch them as a recorded session down the track. Let's go back to the Moodle site. I did warn you that the Moodle site is around the thing that everything revolves, and that's why I want to ensure that you're aware of the material that's there and can work around it. Okay, so on the Moodle site, we also have information about timetabling, which is really just drawn straight from the unit profile. And the assessments, that's where you'll click to lodge your assessment either here or in the top left-hand corner. Both links take you to the same place. I've provided some additional resources, and I'd urge you to have a look at the AGLC. I'll have to change that acronym, which is wrong, but some quick guides there so you know what you need to consider. Now, for week 1, because I didn't provide a live session last week, I've given you something from last year just to give you an overview and get you started. Much of what I'm covering now may well have been covered last year in that introductory seminar. Look, I just have a little thing about voice recognition. When you're studying, I'd urge you to consider voice recognition. I don't care which product you choose. I happen to use Dragon. But the reason I like voice recognition, and the reason I urge you to consider it, is that it is an opportunity for you to advance your advocacy skills while you are typing. And you think, what does that mean? All right. So what I mean by that, and it's explained in the short video that I provide, which is actually years old, and I'm much better at it now than I was back then. But the idea is that as you're reading a material, if you come across something which you think is important, without having to stop and type, you can resource a number of materials, but you can try to improve your advocacy because you are practicing speaking about the issues rather than just typing them. Anyway, that's a little bit of personal preference there. I appreciate that, but consider it. Now, going back to the Moodle site, there's an important document, I think, called the assessment guide by me and a sample document by me. I'm just going to click on this and show you what I mean by it. The sample document, I'm happy for you to keep it, use it as a precedent, send it to others, so you have full license over it. It's something that I prepared, and I prepared it years ago, and I've sort of just changed it and upgraded it from time to time. because when I was teaching Introduction to Law to students, and I still do, I found that they were making a lot of simple errors. Now, winding it back one step, given that most of my work is done in terms of my teaching work anyway, is for law students, I usually say to them, before they present a document, ask if they're happy for, is it a document that they would be happy with if they're charging $400 an hour? If somebody's charging $400 or $500 an hour, which is pretty typical for lawyers, as the recipient of the document and the bill, you expect it to be professionally put together. And I saw so many simple errors, just basic ones like not using consistent fonts or headings. Now, I've selected a title, and you can see up here it's title. I've selected subtitles. You can use headings if you like instead. But whatever it is, make sure it's quite consistent. This is actually a really basic document in many ways, and many of the students present documents that are much more effective in terms of presentation than this, but it's pretty good. But there are a few things that I want to bring to your attention. The first is that it's not just the format which is useful, but it's also the content. Now, in terms of format, you'll see that I've used the footnote referencing, which is what I require you to do. But read the content, because it will give you some guides as to what is important and what I regard as important. So, for example, if you're referring to a case, do so by the legal citation, which in this case, Humsey Hancock Re. You'll see that's the legal citation, square brackets 2007, QSC 34. Don't provide me the internet link. I don't care if you sourced it through a particular link. What I want to know is the legal citation. That's just a legal matter, which is probably different to what you're used to if you're using Harvard referencing. Okay, so read that in full, and hopefully you'll gain something from it. The other thing that you'll probably pick up on from that document is that I have a particular preference for style. I like people to use short sentences where possible. What I dislike is the use of long, convoluted sentences which ramble, which use pompous words. The old-fashioned way of legal writing is well and truly in the past, and I'm so pleased about that. So we don't use legalese. So, don't use things like herein, before, thereafter, all those sort of legal things that we used to use. Bit of nonsense, really. Legalese, we don't use that anymore. So your writing should be aimed to communicate readily, and sometimes the use of short sentences does that, whereas the long convoluted sentences make it difficult to do so. Okay, let's go back to sharing the screen, and you'll see that there's some further material regarding the AGLC, and then we go on each week to provide you with the reference reading and the lecture notes. Now, you'll see some of these things are greyed out. That on my screen, you won't see them, because when they're greyed out on my screen, it means that they're not available to you. Okay. All right. So, how do we deal with this huge textbook? How do we deal with the reading? How do we cope knowing that it's not just a matter of reading the textbook? You need to read statutes and you need to read cases. It's overwhelming. But we'll try and make it a bit easier for you. The first thing is, as I mentioned, I previously, years ago, when 8th edition came out, I prepared Zoom sessions by way of commentary, chapter by chapter, and I'll upload those in one set. I haven't done that for the 9th edition, it's brand new, but I'll do that progressively and I'll roll that out as well. So, and what I mean by that is that it's essentially a summary and annotation that I provide. So if you look at, this is the 8th edition, you'll see that chapter 1, I've highlighted things. When I highlight, I like to highlight so that whatever is highlighted actually reads as a sentence. It makes it easier when you're doing your summaries. So I've highlighted the various parts that I think are important. I'll relay that to you in the course of my summary. But you'll see here I've written little notes on the side, etc., by way of annotation, and I'll add those things in as well. So that hopefully will be a guide to the textbook. As we proceed, I'll try to direct you to the important parts of the legislation and the important cases that you should at least consider. One very important thing that we need to do, and then we'll wrap it up. And thank you for being patient if you're still with me. I appreciate that. I'm going to go back to the Moodle site because there is one other thing I do want to stress as important to you. I mentioned that in week 1, we didn't have a problem. Week 2, we do have a problem. Now, the problem here is a request for you to consider an overview of the nature and structure of environmental law, which is good. Let's click on that and see how people are responding so far. Lincoln Roberts, thank you very much. And John, we have material from them. The idea is that each week you click on this thing, add a new discussion topic, and you provide your response, and we'll talk about that during Zoom sessions. So at the moment, I've got one response with one reply. What I want to do is see everyone in the class adding something to that discussion topic each week. Okay? I haven't given you many problems each week, but I expect that the problems that are there, you do answer. Okay, that's a quick overview of this course, the assessment, what's involved, and the sorts of things that I'll do in the course of the subject. Thank you for your attendance. We'll see you next week, and apologise, this is a re-record because my recording failed first up. All the best, and we'll see you soon. Bye.